Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and today's guest is Michael T. Cahill. He is professor of law and emeritus president and dean at Brooklyn Law School. Good morning, Professor.
Good morning.
I was getting ready to call you dean, but I know that you are a recovering dean, right?
Indeed.
So I thought it would be nice to talk initially about your experiences deaning. My understanding is you were co-dean and professor of law at Rutgers for 3 years, and then you were president and dean of Brooklyn Law School for 4 years, stepping down a year ago on July 1st, 2023. So first, let's talk about what you've spent your time doing this last year.
Yes. I've just stepped down as dean a year ago, and I've been making the transition back into teaching. It will be an even easier transition in the upcoming year as I'll be on sabbatical. So I will have no responsibilities. But it was interesting getting back into the rhythms and getting adjusted to the pace of teaching. And it made me pleased that even as dean, I had continued to teach, as some of our colleagues do and some don't, but I think it's useful, and I certainly found it useful not only while I was dean, but as I have transitioned away from deaning, to not have lost my grip on the demands and pace and way things proceed in the classroom. Thought it was very helpful as dean to do that because it gave me a sense of what my colleagues were doing and reminded me that I was a professor as well as a dean, which was indeed part of my job title even then, dean and professor. And now that I'm no longer a dean, having kept up with that makes me feel much less behind the eight ball and gearing up to teach sections of criminal law and property as the school year resumes. What's been interesting, perhaps a bit challenging, is getting back into the rhythms of scholarly life and writing and researching, which was something that I decidedly put on the back burner when I was dean. I thought as dean that it was important to remain a professor to some extent, but I had a sense that I could write or teach, but probably not both, in addition to my deaning responsibilities.
That's for sure, yeah.
And I made a conscious decision to focus on teaching rather than writing, partly because it was a way of connecting with students, as well as remaining a colleague of my peers on the faculty, partly because it was something that I knew I was doing that was useful for the institution, which is not always something one can be assured of when one is producing scholarship. It may have payoff that is immediate or longer term, but it's hard to know whether a particular project is going to go anywhere or amount to anything. So I felt like it was a more useful thing personally and professionally and institutionally to be teaching rather than focused on scholarship. So I have only been writing short things on deadline as dean rather than large-scale research projects. And so getting back into the pace and manner and mechanisms of reading far-flung works that may have some immediate utility for the project that I have, but also may pay off later. It's been delightful, I must say, and it's been exercising different intellectual muscles than I had been accustomed to doing, but it certainly takes some thought and some self-motivation to get back into certain habits that one had put aside as dean.
So you have something to show for it, at least one big thing to show for it that's coming out this fall, the 6th edition of Criminal Law Case Studies and Controversies that is an Aspen publication. So if you wouldn't mind telling us about your co-authors and what people can expect in this brand new edition of the Criminal Law Casebook.
Sure. So my relationship with my co-author, Paul Robinson, goes back over 20 years now. He was a professor of mine when I was in law school 25 years ago now, and was also my boss when he and I worked together on a project to write a new criminal code for the state of Illinois. He and I have, as meaningful part of our background, efforts to engage in criminal statutory reform, sometimes at the state level, in my case in Illinois and Kentucky, sometimes at the national level, in his case, in projects involving nations all around the world to write new criminal codes. And that, I think, has informed the way he and I present the casebook. And he originally was the only author on this casebook. And a few editions ago, both Shima Bauman and I joined him as co-authors. But the main focus of the book, or the main methodology of the book, is to orient the reader around the fundamental fact that criminal law is statutory law. And that is why, unlike a number of other casebooks in other fields, or even in criminal law, is not called criminal law cases. It is called criminal law case studies, because that is the manner in which the narratives are presented to the students. They're not given judicial opinions where a set of facts are presented in a particular way with a particular slant, perhaps by a judge or set of judges who know how the case is going to come out, nor is the law presented to them with the final result and opinion all wrapped up. Rather, they are given a narrative account of something that happened in an actual place with photographs of usually the people and places involved. And much like a prosecutor or defense attorney would, they don't know how the case is going to turn out. They just know what happened and they have to react to it. And they have to react to it specifically by connecting the facts they have just read with the statutory materials they are given afterward, that are the statutes drawn from the particular time and place where this actual criminal law case occurred. And we have cases from all around the country. Indeed, a couple of them are from other countries. And the students are, or at least one is from another country. And the students are given the law as it was in that place at that time. And they're expected to work their way through the statutes at hand in the way that a lawyer would. And so they're very much put in the posture of a real lawyer and very much focused on the task of statutory interpretation as opposed to reading case law. And we think that's an important way to present criminal law. Both on its own, it's an important way to learn criminal law, but it's also an important aspect of the criminal law course within the first year curriculum. I think the fundamentally important aspect of teaching criminal law in the first year, which is why almost every law school does it, is not only to teach about criminal law as a particular body of law and acquaint students with that subject matter, but also as a way of learning how to read statutes so that you are then prepared to do so in later cases that you're going to take on the bankruptcy code or the tax code or any of a number of other codes that you'll be reading in more depth in later years.
Well, I love that. And I imagine the students really love that, playing prosecutor or defense attorney with these case studies that you put in the book. What sort of feedback do you get from students?
It's generally positive, although I will say a lot of them are thrown by the fact that the format of the book is so much different from the other books that they get. But I think the teaching opportunities, as you suggest, in the classroom give you a chance to do things that are different than might be going on in some of their other classes. And that has a lot of payoff in terms of the experience that you can have in the room. When I teach using the book, I force students into the role of prosecutor and defense attorney. And rather than calling on them in the moment in class, as is common in the first year, I warn them a week in advance that a group of 4 of them are going to be responsible for a particular case that we'll be dealing a week later, 2 as prosecutors and 2 as defense attorneys. And I expect them in the intervening week to get together both with their partner on the prosecution or defense side and with the team on the other side to think about what exactly they want to charge or what arguments they want to make, and to make an effort, as real world lawyers do, to plea bargain the case. So they're thrust by the book in the position of being a real lawyer, and then I'm able to put them in the position that the lawyers who handled those cases would have been in, with the opportunity to bounce ideas off someone on their side and then talk about the case with the parties on the other side. And then their job when they're on call in the classroom is to explain to me whether they arrived at a plea bargain, and if not, why not? And sometimes I learn that the 2 prosecutors didn't agree with each other. Sometimes I learned that the prosecution or defense couldn't come to terms, and very frequently they end up arriving at some sort of bargain. But then they have to explain to me why they settled there and not in some other place, why the defendants were willing to accept whatever bargain they struck. And as I remind them, this is what happens in actual criminal cases, because 95% or more of cases never go to trial. They are resolved prior to trial. And so they are dealing with cases in the way that real world lawyers do, and going through similar thinking to what real world lawyers do, thinking about what the case would be like if it went in front of a jury, thinking about, in some cases, the ethics on both sides of thinking about what they could charge, whether on the prosecutorial side they should charge all of the crimes that seem to be supported by the letter of the law. So it's a great opportunity to explore both what criminal law is, as well as how it works, and also think about some of the ethical lawyering ramifications of what they're going to encounter as lawyers.
Well, that's terrific. I love that that's the way you're teaching it, and I certainly think that's very helpful to them in all areas of statutory interpretation. But as a dean, what looms large in my life every day is the idea of the next gen bar exam. And it seems that this case study method that you're already utilizing and have established over many editions will be an excellent way to help get students ready for this different type of assessment they will have in the next gen bar.
It's always interesting, particularly in the first year, to think about what balance of doctrinal knowledge and skills development one is pursuing in the classroom. And obviously you need to have both. And the case study method and grappling with statutes is a great opportunity not only to learn some law, but to develop skills. Then in other parts of each section, we complement the case studies with a further description and explanation of the doctrine in the relevant area of law, so that they're actually learning some concrete legal rules about the law of accomplice liability or criminal attempt or what have you. And then those things are testable by means of multiple choice questions and other things that are given on the bar. Try to be mindful of how the bar exam works and what the multiple goals of the course are in terms of understanding what the law is and being able to answer a question about what the law is, but also thinking deeply about why the law is what it is and whether it should be different from what it is, and also being ready to use and apply the law as it stands in a particular concrete factual setting. And those are all tools that we hope will be helpful in their toolbox, both as they prepare for the bar and as they emerge to practice.
Certainly. You mentioned that you have been involved, you and your co-author, in extensive criminal statutory reform efforts at the state level, national level, and in some cases international. But when you think of the area of criminal law currently in the United States, where do you see the most need for statutory reform?
Oh, it's all over the place. And I think my views are different than they would have been a little while ago, in part because I just finished teaching a seminar that I had never taught before on the misdemeanor system. And one thing that I'm pleased about with our casebook is that while we have a chunk of the book that is about the crime that most first-year criminal law courses focus on, namely homicide, there are also sections on other kinds of crime, including property crime, technological crime, white-collar crime, and most importantly, from my perspective, possession offenses, which are both conceptually interesting and practically important and give an opportunity to focus on different kinds of low-level offense that are more debatable in terms of whether they should be criminalized, and also at the same time profound in terms of how many people are subjected to these offenses. And having turned from first-year criminal law to a seminar on misdemeanors, which don't get focused on as much in most case books, but are 80% of the criminal docket in pretty much any jurisdiction in the United States, have a huge effect on literally millions of people, in the tens of millions of people each year. A lot needs to be done to think about how the misdemeanor system operates, partly in terms of its process, partly in terms of the substantive law that applies, and whether there should be meaningful reform, not only at the state, but at the local level where a lot of misdemeanors exist. But unfortunately, many localities don't have the wherewithal or the resources to think seriously about law reform and how to have coherent, comprehensive, yet understandable criminal codes in the way that states do. So I think just as there's been a wave of law reform following the Model Penal Code in the 1960s, at the state level, what might be overdue is a similar model set of statutes at the local level to set out lower level crimes governing what are sometimes described as public order offenses or public decency offenses in a way that covers the things that are important to criminalize, but doesn't over-criminalize, doesn't have the frequent problem of redundant, overlapping, overbroad criminal offenses. I think that's perhaps the next step, because local law offenses suffer from all manner of difficulties.
Well, congratulations again on the 6th edition of Criminal Law Case Studies and Controversies, published by Aspen, that'll be coming out this fall.
That's right.
Now let's get back to your 7 years deaning. So I'm intrigued by the co-deaning model, and you were a co-dean at Rutgers that has now gone back to a single dean, as I understand it. And I know there's a pair of co-deans that were at Case Western, but they are now going back to a single dean model.
That's right.
So I'm not sure that that model is being utilized moving forward, but I'd love to hear what your perspective is regarding should it.
I think there are a lot of positives actually to co-deaning. And it's funny, during my time at Rutgers, I was approached by an education PhD student who was writing her thesis about co-deaning. And she ended up being able to specifically focus it, for the sake of consistency, on the experience of being co-dean at a law school. And it surprised me looking over her thesis, which I just was reading last week, because she sent me a copy. So your question is timely. It surprised me to find that she had examples of 6 or 7 different law schools, which had been anonymized, although I could figure out which one was mine, that had co-deans. And I know that, I imagine Case Western may well have been one of them. I know the University of New Mexico had co-deans for a time, although I don't believe they do now. And clearly there are a handful of other schools that have gone that route, although in many cases temporarily, sometimes on an interim basis, sometimes for particular reasons. In the case of Rutgers, obviously no small part of it was that we were one law school in 2 locations, and that remains the case. Rutgers Law School is in both Camden and Newark, New Jersey, now has a single dean responsible for the entire law school, but I think retains a pretty strong vice dean model of local authority over each location, as it were. I found the co-dean model to have a lot of appeal, and if anyone is truly interested, I will explore sharing a copy of this PhD thesis with them to think about the ups and downs and complications and virtues of co-deaning. But there are a lot of ways that it can benefit the school, in that the co-deans can decide what responsibilities they want to focus on. Not every dean is interested in or good at wearing every hat that deans are required to wear. Some people would rather focus on outward-facing things like fundraising and alumni relations and prove very adept at that. Some people are more interested in budgeting and finance or internal administrative affairs. Some people like managing the various departments. Some people are interested in infrastructural projects, to the extent those are going on at the law school. And it's not necessarily the case that you're going to find one person who has the aptitude or the interest to pursue all of those things, or the time to do all of those things all at once. So sometimes just having 2 people to devote to all of those tasks can be helpful professionally. And personally, it's extremely useful to have another person to talk to about the various issues that you're confronting on the job, and not only think through decisions on a substantive level, but just have someone whose shoulder you can lean on in difficult times, and that you can talk to about things that would otherwise be confidential. There's a strong network of law deans. I was happy when I came to New York to be part of regular conversations among all 15 of the law school deans in this state. And I had and still have warm relationships with a number of my fellow deans, and they were a very helpful resource, particularly during the pandemic. But it's unique in the situation of having a co-dean that you can really talk about things that in some cases you literally can't talk about with anyone else, and have an opportunity to think through them and feel like you're arriving at a better decision, and also have the confidence that comes with knowing that you bounced something off of someone else. So I think there's a lot of upside actually to co-deaning while one is doing it. And I thought something that in my view was helpful at Rutgers while I was there was that when you have 2 deans, they don't both have to start and stop at the same time. And so when I became co-dean, there was another person who was already co-dean in Newark and had been on the faculty for a long time and was very familiar with the institution. So it was extremely useful to me as an external hire to have the benefit of his familiarity with Rutgers and with being a dean at Rutgers. And I hope that the same was somewhat true when he stepped down and was replaced by a new external hire in his location. And so there was some transition, but also the stability that came with having one dean who had been in place and another who was coming in as a new set of eyes and ears. So it sort of enables an interesting balance between stability and consistency and dynamism, that you have turnover, but at the same time, perhaps some stability. The challenge obviously is making sure that if one dean is remaining and one dean is being replaced, you have to make sure that the relationship is going to work out between the two people. And so it might possibly add yet another wrinkle to a hiring process that is already pretty complicated to make sure that you're finding a good fit between one dean and another. I was fortunate that my relationships with both of my co-deans were positive, but that is certainly a particular challenge of that model, making sure not only that you like it in the abstract, but that when it comes down to finding two people, you're going to find two people who are both good and are complementing each other in the right way.
So I'm curious, did the thesis that you discussed come up with any sort of conclusion about co-deaning models in law schools?
Not firmly so. It was really sort of elaborating a lot of the kinds of benefits and possible concerns that I've been articulating. I don't think it did or was seeking to offer any sort of comprehensive take on whether two heads are always better than one. Or it's sometimes desirable. And I think it can depend quite a bit on the situation that the institution finds itself in, and can depend a lot on the personalities of the people who would be occupying those roles, as is true of any deanship.
Certainly. Well, thank you for sharing that experience. And so then you moved from being a co-dean to being the president and dean of Brooklyn Law School, an independent law school, which has its own set of challenges and opportunities for 4 years. Tell me, what goes into the decision to return to the faculty, and how did you prepare for that transition?
Yeah, I think it is a helpful thing, and I tried to think about this even as I was going into the deanship. I think it is useful for deans to think about what they will do afterward, or whether they will be ready to serve either on a faculty role or in some other role if they plan on doing something else after they step down as dean. But I always wanted to fulfill my job title of professor, which is not a job title I gave up when I was also dean and president, both during the time that I was in it and as a means of being readier for stepping back down onto the faculty whenever that time came. And I think that was useful. And I think it makes it easier for a person to let go of the deanship if they feel comfortable with what they will be doing after the deanship is over. And I think it's important for deans to remember that the last way in which they will serve their school, at least in the dean's role, is to ensure a smooth transition to their successor, part of which is making sure that they themselves feel comfortable with relinquishing their decanal duties and have the humility and generosity to support their successor and to move into a different role themselves. So it has been helpful, I think, both during my deanship and after, that I was maintaining some teaching load, both at Rutgers and here at Brooklyn, so that I was continuing to interact with students. I was continuing to think about what I could and should be doing in the classroom, particularly during the pandemic. It was very useful that I, along with my colleagues, was having the experience of making certain modifications to what I had to do when the pandemic struck. But I think it was particularly useful in making the transition back to the faculty both less scary and more comfortable, because I didn't feel like I was moving back to a task that I had completely foregone during my time as dean. I think that was helpful. I think it made me more comfortable both as dean, and has been a positive experience as I've been back on the faculty. But as I was saying to you earlier, I was much less active as a scholar during my deanship while I remained a bit of a teacher. And it has been an interesting experience to shift gears. It really does feel like a shifting of gears in moving from the many different tasks that one is juggling all at once as dean to devoting a lot more sustained time and attention to single long-term projects in the way that one does now, or does more as a professor. And sometimes that's a casebook. Got another book project that I'm hoping to start tackling when I go on sabbatical, as I will be in the upcoming year.
Yes, enjoy that. You have earned it. Let me ask you, before we conclude, the question that I ask all guests, and that is, what are your predictions for the future of legal education in the coming decade?
Yeah, I'm a big believer in the expansion of legal education outside of the JD degree, and I imagine and expect that it will continue to move in that direction. So to some degree, the future is now, in that even over the last 10 to 15 years, we've seen a rise of masters of legal studies and similar degrees that are meant to provide legal education for non-lawyers. And I think that trend is likely to continue. And I think it reflects ways in which law schools are doing the kinds of things that business schools have been doing for quite some time. In that, some time ago, when the demand for the full-time graduate MBA degree started to decline, business schools, being business schools and therefore smart about how to market themselves and provide useful degrees, and education moved into things like executive education and different kinds of MBA that were not necessarily full-time, but also focused a lot more seriously on undergraduate education. And now you see business majors being among the most popular, the undergraduate level, which has been extremely successful for business schools, hasn't been great for humanities programs and the liberal arts, but certainly has been useful for business schools in expanding their sense of what they do and how they do it. I think law schools have the opportunity to do something very similar, particularly law schools that are part of universities, as mine is not. As you know, Brooklyn Law School is a freestanding law school and so doesn't have these kinds of opportunities. But you see other schools prominently, including, say, the University of Arizona, developing quite expansive undergraduate law programs that I see as being an excellent opportunity, done right, both for law schools to expand their mandate educationally and think about other kinds of education that they can deliver to people who may not be planning to practice law, possibly as a precursor to graduate legal study and becoming a lawyer, possibly not, but also to partner with the humanities and social science professors in other departments to really strengthen what's going on in those departments. Law, even more than business, is historically an interdisciplinary field, both in practice and in scholarship and in teaching. And I think the opportunities abound for law schools to partner with other undergraduate departments whose constituencies or whose membership is flagging at the moment, and really bolster what is going on in English and philosophy and history and other fields, while also introducing something that is intellectually exciting, but also potentially professionally practical for undergraduate students. So I don't know if that's a prediction about what will happen, but it is certainly a forecast about something that could happen and that I think is a potentially positive move as law schools think about how to complement what they do in the JD program.
Yeah, I think you're exactly right. We partnered with the business school here at St. Mary's last year and developed a business and law undergraduate major. Right. And it was popular last year in its inception, and we hadn't started it in the beginning part of the year. And this year, as we're looking at the incoming freshmen, it's the second highest major. So people are interested in exactly what you're saying, interdisciplinary undergraduate education that might include law. As for the Masters of Legal Studies, that is the first time we met. We met at a graduate law conference, and we hosted one of them this past year. We'll be hosting one again this coming year. But yes, that is certainly growing, the one-year masters at law schools. And I think your prediction is dead on. Well, thank you so much for sharing some of your dean experiences with us, your predictions about the future of legal education, and the exciting 6th edition of Criminal Law Case Studies and Controversies that will come out in fall of 2024. And enjoy that sabbatical.
Thank you. I most certainly will. And it has been an absolute pleasure. So I appreciate the conversation and your time.
Thank you. I've enjoyed speaking with you as well. And if you've enjoyed listening and would like to hear from additional thought leaders across the Academy, you can go to the Aspen Leading Edge podcast webpage or find the podcast on any of your favorite podcast channels. Thank you.